So going into our Act 22, the Individual Investors Act, I would like to introduce the next speaker and panel. He's a corporate attorney who holds a master's in law from Northwestern University. His firm advises clients on Act 20 and Act 22 solutions. Omnia Economic Solutions is the only local firm that has fully operational offices in New York and San Juan, Puerto Rico. He has a license to practice law in Puerto Rico and Washington, D.C. Another very good friend for our firm and personally. So I present to you the managing partner of Omnia Economic Solutions, Mr. Roberto Corretjer. Roberto.
Thank you very much, William, for those words. I hope that everyone can try to stay awake after such a nice lunch. As William mentioned, my name is Roberto Corretjer. I'm a senior partner at Omnia Economic Solutions. We cater to Act 2022, providing turnkey services in San Juan, Puerto Rico, and we have a fully operating office in New York as well. I will be discussing with you guys today the benefits, requirements, and some hurdles regarding Act 22. And I have divided my presentation in 3 stages. The first stage will be the benefits of the Act, which are pretty much straightforward. The second part will be on how to qualify for the process and the petition process. The third part of my presentation will be pretty much conducted by my panel here, which all of them are clients of my office, and they hold their Act 22 decrees. So earlier on I realized that I have way too many slides for the short amount of time that we have to present, so I'm just going to skip on some of them in order to make sure that my clients and friends have plenty of time to share their experiences with you. As some of these previous speakers this morning mentioned, there's tons of benefits and securities involved by moving down to Puerto Rico. We have the U.S. Constitution being forced down here with federal laws, U.S. currency, FDIC regulated banking system, and we operate within the U.S. custom borders. The Act 22 of 2012, or better known as the Individual Investors Act, was signed into law on January 17, 2012, and the main tax benefits of such act is that there's 100% tax exemption on dividends, 100% tax exemption on interest, and on capital gains, all of them which have to be sourced in Puerto Rico. The objective of the Act 22 and the spirit of the law is to promote and bring investors down to Puerto Rico and can help inject new idea, new capital into our struggling economy. Like Baco mentioned this morning, there's over 100 applications being received per month. The program is extremely successful, and as you can see later on from the experience of my friends and clients, the program actually works very well. Now, on to the benefits. So 100% tax exemption on interest. And those interests have to be based on the residence of the payers, not like could be interest coming from other places. They have to be Puerto Rico sourced. Same with the dividends, and same for the short and long-term capital gains that were accrued after becoming a Puerto Rico resident. Those capital gains that are accumulated and realized prior to the relocation to Puerto Rico will be taxed at 10% if recognized within the 10 years after the relocation, and at 5% if recognized after the 10 years. This means that unrealized gains at the time of the relocation to Puerto Rico that are recognized within those 10 years remain considered to be sourced in the U.S. and therefore subject to federal taxes. Interest paid by corporations created or organized in Puerto Rico or by individuals who are bona fide residents of Puerto Rico are considered income from source within Puerto Rico and therefore excluded from those taxes. Now, the benefits of the Act 22 decree are valid until December 31st, 2035. They need to be accrued and realized before that date. I'm going to skip this part because I'm going to talk about it a bit further down my presentation regarding new capital gains, and move on to how can someone qualify in order to get the benefits from the Act 22 decree, which in my opinion is the most important part of the entire process, making sure that you comply with the standards set by the IRS to become to be considered a bona fide resident of the island. Okay. So in order to be considered a bona fide resident of Puerto Rico, the individual moving into Puerto Rico needs to meet all of the next 3 tests: the physical presence test, the tax home test, and the closer connection test. All of them must be met in order to be considered in the eyes of the IRS a bona fide resident of Puerto Rico or a U.S. territory. The physical presence test could be passed by meeting any of the following 5 criteria. The first one, which is the most common one and the one that most people get to know about at the beginning, is spending 183 days minimum during that tax year in Puerto Rico. That alone will create a presumption that you're a resident in Puerto Rico for the eyes of the Puerto Rican government, but not in the eyes of the IRS. Another way of meeting the physical presence test is by spending 549 days during a 3-year period, provided that the individual is also present in Puerto Rico for at least 60 days in each calendar year. Another way is to be present in the U.S. for no more than 90 days and have earned income of less than $3,000 in the U.S. and present more days in Puerto Rico than in the United States. The second test will be the tax home test, meaning that an individual declares that his home in Puerto Rico is also where his regular place of business is. If you are retired and you are not working anymore, then the tax home test can be met by declaring that your home here is your residence, is your place of residence, meaning the place where your family is and the place where you intend to come and stay. Now, the most important of all the tests for me, let me move on here, make sure I'm on the right slide, is the closer connection test. Because this one, there's no magic formula. It's a combination of, and I place here the 9 most important factors. If you go into the code, there's maybe over 20 additional other factors that the IRS takes into consideration to see if you actually meet those qualifications. But I listed here the 9 most important, which are that you have an individual permanent home in Puerto Rico, if you have a family, that your family is down here. Where are your personal belongings? Where you have your car? Where's your jewelry? Where's your clothing? If you belong to a club, your social club, where you attend church if you're religious, where do you conduct your personal banking, business activities, where do you hold your driver's license, where do you are registered to vote, and obviously, what do you designate as your home, as your main residence in formal government documents? Do you have to meet all of those criteria in order to pass the close connection test? The answer is no. But obviously, the more that you add, the better that you will be positioned to, if it comes to it, argue with the IRS that you are indeed a bona fide resident of Puerto Rico. Now, there is an exception in order to be considered a bona fide resident of Puerto Rico for the first year, which is called the year of move exemption. And it can be satisfied if you were not a resident of Puerto Rico during each of the 3 preceding years, and during the second half of that moving year, you could not have had a taxable home or closer connection to the US or any other foreign country, meaning that you're in the United States, all of a sudden it's March, you get an offer to move down to Puerto Rico or decide to close down your business, move down here. You move down here in March or April, you open your business, you declare your tax home down here, and you stay for 183 days or plus. If you do that and stay a resident of Puerto Rico during the next 3 years, then you can claim that that first year, your moving year, you were a bona fide resident of Puerto Rico. This is just an example of on the left side, you have an average of what the tax rates at state and federal level look right now in the United States, and how can that be lowered down to 0% under an Act 22. Now, going to non-Puerto Rico building gains. What does this mean? This means that while you were being a resident, a bona fide resident in the United States, you accrued some gains. And then you decide to move down to Puerto Rico. And while being a resident of Puerto Rico, you realize those gains down here. If so, then you are subject to a 10% tax, which is the actual rate right now. Could change, obviously, in the future. For the first, if you realize those gains in Puerto Rico for the first 10 years, after 10 years, you're subject to only a 5% tax. Now, those gains that are accrued in the States and are not realized until you move down to Puerto Rico are also subject to federal income tax. Although you will get a credit, according to Section 937 of the code, those taxes are creditable against such federal income taxes. And after the first 10-year period of moving down to Puerto Rico, then the IRS does not consider those realized gains taxable. The process is pretty straightforward. There's an application, includes an application fee of $750. The application needs to be sworn by a public notary, presented at the Department of Economic Development. After the application has been filed, successfully filed, including all the documents or supportive documents that are required, including a criminal background check, a copy of your driver's license, passport, evidence that you have secured a residence down in Puerto Rico. Eventually, if you're accepted, you will get a notification from the Department of Economic Development saying that your Act 22 decree has been approved. And if you so decide to accept it, you have to file a $50 check accepting the decree and a $5,000 contribution that it's paid at a tax office. Now, recently, Act 22 suffered an amendment back in middle of November 2015 that every single application that it's filed on or after December the 1st, 2015, those Act 22 decree holders will be required to buy a residence in Puerto Rico. The law, it's not clear if you need to buy a specific type of residence, if it could be just a piece of land, if it could be something like like a studio or a huge house. There's no guideline into it. And we just found out from our friends at the Department of Economic Development that they're going to give the Act 22 holders a 2-year leeway to comply with that. So you can actually get your Act 22 decree, move down to Puerto Rico by leasing a home, and then if you do decide that this is something for you and you want to make sure that you're in compliance with the decree so that you can get the tax benefits, then you will be required to buy a home. A lot of my clients keep asking me the same question. Can my decree be taken away by the government? Can it be revoked? What is the process? And the answer is yes, but it's under some specific circumstances. The first one will be that the Act 22 decree holder breaches any of the terms established on the decree. For example, now moving down to Puerto Rico, 2 years passes after you get your decree, you don't acquire a residence or a home, that will be a breach of the terms of the Act 22 decree. The second one will be that the Act 22 decree holder does not pay the corresponding taxes. To give an example, you're working on here for a company, you have an Act 22 decree, you receive salary, and you don't pay your taxes according to that salary. That will be considered a breach of the terms of the decree as well, and a reason for them to revoke the decree. And the third one, which is pretty straightforward, is that you provided false information or lied in order to obtain the decree. In any of those three circumstances, if you receive a notification that for some reason they're taking away your decree, the Act 22 decree holder is still entitled to a formal hearing to argue his case. I included other slides that I'll be passing around. They're more, talk about more about the quality of life in Puerto Rico and a bunch of stuff that has already been said this morning. I don't want to bother you with something being very repetitive. I would rather have my clients talk more about that part, including their experience with the process of acquiring their Act 22 decree. At the end, we'll have some Q&As. If someone has some questions, we'll be more than happy to answer.